SJC-13429, Cathleen M. Cirone, and another v. Jane K. Furnas.
Okay, Attorney Williams, whenever you're ready.
Good morning, and may it please the court. I am Talia Williams. I represent the appellant in this matter, and I'm joined by my co-counsel, Jesse Belcher-Timmy. This is a fairly simple case in the sense that the narrow issue that needs to be resolved by this court is whether or not a severance of a joint tenancy took place by operation of a decree that simply incorporated a party's agreement. It is my client's position that that, of course, has not taken place. Joint tenancy is such a significant property right, and it is required to be created expressly and in writing in an instrument. So it would follow that in order to waive that right, that waiver would also need to be expressed. This was a situation where there was a partition case. Yes, there is a compromise agreement, but the compromise agreement is completely silent as to how this property will continue to be held. The agreement is silent as to whether or not this benefits heirs, successors, and assigns if somebody were to pass away. It does not state that there's any change in the way that the parties are holding this property, and it simply just contemplates a future sale. Yes, with some parameters, but...
But it doesn't, I mean, the appeals court decision, which is detailed, talks about possession, right? That there's no longer possession, right?
Right.
The person clears out.
Your Honor, I think that there's a very clear distinction between legal possession and physical possession. In this matter, this man had vacated in advance of them ever entering into this agreement. That is reflected in his affidavit of objections. It was a matter of him returning to remove some property.
Isn't the physical possession sort of converted? It takes on a legal, it becomes legal possession when you enter into agreement on that, doesn't it?
I would disagree, Your Honor. It doesn't state that he can never return, and although I understand that you can't credit my clients.
The issue is not whether he never returns, it's whether he has the right to possession, the same right of possession, right?
And I would argue that legally he does.
But what's the basis for that?
That he has simply just vacated the property.
But no, he's entered into an agreement that legally obligates him to leave.
But it doesn't indicate that he can never return, and it does not indicate that ownership has in any way been changed. If you think about it in the context of, let's say, a separation agreement, somebody might move out in the interim while a divorce is pending. They might be joint tenants, and by them moving out, they might even enter into a temporary agreement that that person could never return, but that doesn't necessarily change their legal ownership of that property and ownership of that possession. And in a divorce context...
This was the resolution of a petition for partition.
Yes.
And they both agreed to this deal. And that deal was codified through the decree.
Correct.
And so that ended the petition for partition, right?
I don't think it did, not entirely. If you follow the way the partition statutes work, in order for something to operate as a partition decision, it has things that have to be in there. There is an example in the record of that, but one of the main examples...
What if they had never, your client had never petitioned for partition?
They would still...
And instead had agreed to the settlement agreement.
I guess I'm misunderstanding the question. So she did...
Yes, you are. Yeah. So here's the question. The question is, what if, I'm a joint tenant,
Yep.
right? And I no longer want to be a joint tenant, just like your client didn't want to be a joint tenant. And instead of needing to file a court action, I say, hey, dear joint tenant, I no longer want to own this with you. Let's enter into an agreement.
Well, as long as there were a writing that was recorded...
Right, like a settlement agreement.
Yeah, I'm not sure that a settlement agreement is enough, but one joint...
Was it in writing?
The settlement agreement? Yes.
Okay.
But it
so
does
what,
not...
What about it was deficient?
There's no reference within the agreement, the four corners of the agreement, as to how it's held, and it's already been acknowledged that it's held as joint tenancies because that's part of the initiating process. There's nothing in the agreement that talks about that changing. And this isn't similar to a divorce where we know we have a law that once the nisi period, it automatically switches to tenancy in common. That's not the circumstance that's here. They entered into this deed. Everybody agrees time and title is not an issue. Yes, they entered this as joint tenancies. Now we're at a situation where that has never been changed in writing. They agreed to certain things to avoid the rest of the lawsuit, to avoid the appointment of a commissioner, and to avoid that sale process.
And to terminate the petition for partition.
But it didn't terminate their individual property rights. And
But
when...
but why? I mean, you
Because-
say that, and that's
yeah.
the key question,
Yes,
but
it's
why?
missing, because it's missing too many things. And that's part of that comes from the partition statutes. When you have a partition judgment, it says you need to have these things for it to be sufficient. One of those things is a holding or a finding of how, the nature of how these people own this property. There's a case for, I couldn't tell you the name off the top of my head, but for example, there's a case that held that decree over here, even though it said it was tenants in common and the petition said it was joint tenants, you're stuck with what came out over here. This document is silent as to those issues. There's nothing in that document that says we're changing the joint tenancy. There's nothing that would have informed Jane, who was pro se at the time, that those rights were going to be changed. The intention could have been, because it's not in there, that they wanted it to remain as a joint tenancy with rights of survivorship. So what this really comes down to, and this
What
decree...
about the agreement gives rise to that interpretation?
I'm
That
sorry?
What about the agreement gives rise to the interpretation that they wanted to maintain it as joint tenants?
It is not expressly waived.
So it's the silence in the agreement.
The silence in the agreement, there's also no affirmative statements that say that this is going to benefit their heirs, successors, and assigns. It is just between the individuals. I think we'd be in a very different circumstance right now if it said we are going to treat this going forward as if we're tenants in common, or I want these rights to go through my estate.
So again, it's the silence.
I'm sorry?
You're standing on the silence in the agreement as to
Correct.
how they're going to hold
Correct.
it in the future.
And since this is such a significant property right that you cannot create unless it's absolutely express.
Can you terminate it unless it's absolutely express?
You can terminate
That
it
is
by
that-
alienation.
Okay.
Which, in this case, there was no other alienation. There was just the decree. Neither party had taken their interest and deeded it out to anybody else or done anything under the law that would have been deemed a different conveyance or alienation. And we know from the recent holding in battle that conveyancing is the point in time where the severance occurs.
For which unity? Time, title,
For all of
possession.
them, essentially.
So you read battle to apply to all four unities.
Yeah, I think that at a time of a conveyance, all of the unities are gone because the interest is completely extinguished. In this case, unless it was severed, Jane owns this property outright because it fully vested in her the moment that Mr. Cirone passed away. So it really
Right,
comes
but the
down to
beginning of
whether...
that question is what's before us, is if it was not severed. The question is, does the settlement agreement sever it? And your position is no, because it's
No.
silent.
Because it's silent as to these issues. I also think that it doesn't even meet the normal basic requirements of a settlement agreement, even if you were to just purely remove it from the
What
partition
are
realm.
those basic requirements of the settlement agreement? I'm not
Very
aware of
clear
them.
material terms that have finality and then everybody can move on. This wasn't the type of agreement where everything was done. There was a 2-year period of time where there could be a refinancing and other things could come up. There aren't terms requiring her to sell. If you read it just on the 4 corners, her only obligation is to list the property for sale. It may imply or contemplate a future sale, but it doesn't require it. It doesn't even include parameters as to when an offer needs to be accepted. So arguably, she could be in compliance with this by listing it in perpetuity and never agreeing to any of the offers that came.
Isn't there an implied good faith?
Well, I'm not suggesting she would act in bad faith. I'm suggesting that the only clear item in the agreement that she has to follow is to list it. And then once listed, if ultimately sold, there are other things that need to be done. But in terms of analyzing this with Battle, it's the same as Battle, different circumstances, different points in the procedure, but the conveyancing event is contemplated in the future, and that is when all the rights would be cut off, is when that sale in the future happens.
Anything else?
Unless the panel has additional questions for me, I think I'm going to rest on our briefs.
Okay, thank you very much.
Thank you.
Okay, Attorney Esposito.
Good morning. May it please the court, Mark Esposito for the plaintiff, Cathleen Cirone. This case is completely different from Battle, and Battle was limited to the context of partition by sale. This was not a partition by sale.
Why doesn't the settlement agreement here fail to extinguish the joint tenancy? In that the terms of the agreement seem to contemplate future action. At some point in the future, the joint tenancy will be terminated, but
Well, they
Not
do
now.
contemplate future action, but there's also, it is a decree of the court, and the parties explicitly agreed that it would enter as the judgment in the case. The fact that it is the judgment means that the partition proceeding has terminated, and a completed partition, by definition, severs a joint tenancy.
But the termination of the partition proceeding, which is hard to say, does that necessarily mean that there has been a partition? Right, so instead of executing on what Jane wanted, the partition, the parties entered into agreement to, in the future, terminate the joint tenancy. And that terminated the partition, but it didn't result in a partition, I think is the theory behind Jane's position here.
I agree that that is the theory.
Why is that wrong?
Because the unities of possession and interest were severed.
But yeah, so explain that.
Mr. Cirone no longer had the right to move back into the property. I think it's clear, again, under sort of ordinary principles of good faith, if the agreement is you're going to remove all remaining property by a certain date, you can't come back the day after and say, okay, well, now I'm moving back in. And their interests were different because there's a possibility that Ms. Furnas, at her unilateral option, she's either going to own the entire property or she's going to sell the property and Mr. Cirone's going to be entitled to a portion of the proceeds. But in either case, this is at her sole discretion. Their interests are no longer aligned, or they are no longer the same. And so those unities are both severed. There's also the issue that, so again, we say the partition was completed. This was a final order of the probate court, and the court necessarily has the authority and the jurisdiction to enforce its own final orders. So even if it were the case that the joint tenancy wasn't severed, and of course we don't concede that because we think it was severed both by the destruction of the unities and by completion of the partition, but even if that weren't the case, there's a final order of the probate court that mandates that Ms. Furnas take actions that she has already agreed to take. And it's her refusal to take those actions, which she agreed to take, and which she was ordered to take by the probate court, that gave rise to the contempt proceeding that led to us being here.
So I don't actually know the answer to this question. what if you and I enter into a contract to do something in 2 years and then I drop dead? Can my heirs enforce that contract?
I think it would depend on the circumstances and what the terms were. We also have in
Well,
this.
let's just say we enter into this contract, the settlement agreement.
So which party are you in this example?
Whoever died, I don't remember.
Yeah, I mean, you would be able to enforce it. And there's also the issue here that this wasn't just a contract to do something in the future. It wasn't just in 2 years, we're going to see what happens. This was every month over the next 2 years, Mr. Cirone is going to make these half the mortgage payments. This is a valuable benefit that Ms. Furnas is getting. And she cashed those checks. She got that benefit. She initiated a partition proceeding, which by definition is going to sever the joint tenancy. So she can't have been surprised that at the end of the proceeding, she no longer owned the property jointly with Mr. Cirone.
I do have a question, if you can hear me,
Yes.
and that is, how would what happened in this case, where you've got a decree, how would other parties, mortgagors, people interested in the property, or somebody wants to put a lien on something, how would they know this was partitioned?
So in this case, the mortgagor, the bank, the holder of the mortgage, was a party to the initial proceeding, so they had actual notice. The appeals court in this case sort of cautioned in a footnote that it would perhaps have been wiser for the decree to be recorded after it was issued, which was not something that happened prior to Mr. Cirone's death. But this is not a case where there's a bona
So
fide.
in general counsel, what happens when a decree in other circumstances is not recorded?
So if there were a bona fide purchaser for value who had come in and bought this property and, somehow Ms. Furnas got all the money, there perhaps wouldn't be a claim by the estate of Mr. Cirone to try and claw back, something from the purchaser because they didn't have notice, they didn't know. But that's not what happened here. What happened
Right,
here.
I know that. I'm thinking about other cases, and I'm thinking about how we frame this. And part of recording things is to put the world on notice if there's an interest in the property. So how is the world on notice by this decree?
So in this case, I'm not sure it's in the record. I believe there actually was a lis pendens filed at the time the petition was initiated. But in addition to that, partition statute, I believe in section 7, so upon the filing of a petition for partitioner, the petitioner shall forthwith cause to be filed in the registry of deeds for each registry district where any of the land included in the petition lies, a notice of the same containing a brief description of the land, and then it goes on to just outline what it is that needs to be included in that notice. But so in this case, had someone wished to purchase the land, they would have seen that a partition proceeding was pending. Again, I believe there also was a lis pendens filed. That person certainly would have had a duty to, or they at least would have been on notice that there was a potential issue that needed to be investigated.
But section 7, it says they shall file a notice. If that isn't done under section 7, a proper notice, then would there be no partition? The statute wouldn't have been met.
So, I mean, it would depend on the circumstances, but the case of Nichols v. Nichols, it's a 1902 case, but it's still good law, and it says that the mere fact that an agreement of the parties does not, parrot all of the terms of the partition statute doesn't mean that it's not enforceable. So if you make a
Right, but
deal,
that's not saying that they can, just because they don't parrot the terms of the statute, it's not enforceable. What we're really getting at is if you don't fulfill the requirements of the statute by filing a notice as required under this. Did your lieutenants invoke this section? Did it mention the partition statute? What does it say?
I'm sorry, I wasn't able to hear that question.
I'm wondering whether the lieutenants that you say was filed about this, did it invoke the partition statute? Did it say this is a partition petition pending?
I mean, as a factual matter, I don't recall the answer to that. But again, this is not a case where there's a bona fide purchaser for value who is being, somehow prejudiced because they didn't know what was going on. This is a case where the very parties to the agreement are the parties to this litigation. Ms. Furnas knew full well what she had to do under the agreement. She initiated the partition, she signed the agreement, she cashed the checks. Came time for her to perform her end of the deal, which was also ordered in the decree. And she no longer liked the deal so much at that point because now it was time for her to fulfill her obligations. But so the
Well, or alternatively, she had now full ownership with no joint tenant, I think is what her position would be.
Yeah, I mean, that would be her position, based on the completed partition, based on the destruction of the unities. I mean, I would say that's simply not accurate. But even if we were to say, for the sake of argument, that the joint tenancy was not severed, there's still the issue that this was a final order of a court. So regardless of who has title to the property, there's a binding court order that was never appealed from. This was the final decree in the partition proceeding, and the decree mandated that Ms. Furnas comply with the steps that were set out in the agreement. So it doesn't matter who holds
And
title.
just remind me, the agreement requires her to list the property?
She had to either list it for sale by, I believe, June 1st, 2020, or she needed to refinance and make a payment to Mr. Cirone by September 1st, 2020. The drafting of that agreement, I would say, is certainly not ideal in a couple of different respects, but it was pretty clear what the intent of the parties was. And I would not want to be in the position of arguing that my client's been ordered to list a property, but that means they can just leave it listed forever and never sell it. I mean, I wouldn't want to make that argument in court. I think it's pretty clear what the parties were obligated to do under the agreement, which, again, there are drafting problems with it. But the whole purpose of the partition was that Ms. Furnas no longer wished to own this property with Mr. Cirone.
And in that context, the requirement to list takes on a new meaning, is what you're saying.
Yeah, I mean, this is in the context of a partition proceeding where ordinarily you would have partition by physical division, which is favored but not practicable for a single-family home on a lot with only room for one home. So necessarily, if you can't divide it, the only other alternative is sale. And this is the proceeding that she brought. She knows there's going to be a sale of the property. Or she can buy out Mr. Cirone's interest, which, again, is essentially a sale of the property. So nothing that happened here was anything that was outside of the scope of just the fact that it was a partition proceeding. The entire purpose of the proceeding was to ensure that these people who no longer wish to own property together were no longer going to own property together. The proceeding was finished by an agreement which was entered as a decree of the probate court And the destruction of the unities severs the joint tenancy. The issuance of the decree, which is a final decree and thus a completed partition, that severs the joint tenancy. But even setting those issues aside, we still have a final decree of a court which has to be enforceable. And that's under the Samar v. Maharaj case, that basically the court has the authority to order compliance with its own orders. So even if it were correct that somehow the joint tenancy survived the destruction of the unities and the joint tenancy survived the completion of the partition, even if that were correct, we still have a final order of a trial court that was not appealed from and that mandates that Ms. Furnas take certain actions which she made absolutely no attempt to comply with. And so even if the joint tenancy were not severed, it would not change the outcome in this case, which is that the probate court's finding that Ms. Furnas was in contempt of its decree must be affirmed.